morning, everyone. Today is June 29th, 2023, and welcome to the New Possibilities Hour, part of the Will Work for Food project founded by Natalie Armstrong Motan in the spring of 2020. Every Thursday morning, Jean Lawler and I are delighted to co-host another cutting-edge presentation for mediators, arbitrators, lawyers, and everyone who negotiates. As you know, there's no charge for these great webinars. Rather, we ask people to contribute to a food bank if they like what they see. And our audiences have been so generous contributing in honor of our great speakers. One of my favorite parts of the webinar every week is when we announce the running total of contributions to food banks by our wonderful audiences. Jean Lawler, would you please do the honors?
Absolutely. I would hate to disappoint you and not have a number for you, Jeff. Well, it looks like we're getting ever closer to the 500,000 mark, little by little. Amazingly enough, we are at $411,918.57 of donations about which we've been told. So if you've made any donation and haven't told us about it and would like to do so, please send an email or a text message, or just reach out to Natalie, to Jeff, or to myself, and we'll be very pleased, thrilled to add it to the total. Thank you so much.
That is just fantastic. Thank you, Jean, and thanks to all of our wonderful speakers in whose honor people have contributed, and thanks to all the wonderful members of the audience who have made those generous contributions. We're very happy to have a guest today, Scott Partridge. Scott has a very distinguished record. Scott had a law firm in New Orleans, Louisiana, grew to 75 lawyers at its peak, doing high-stakes commercial litigation. In 2006, Scott accepted the role of Chief Deputy General Counsel of Monsanto Company and assumed responsibility for a variety of high-profile litigations, including class actions, mass torts, commercial disputes, as well as investigations and litigation involving the federal and state governments. With an intense high-profile litigation docket, Scott created new processes to resolve disputes while also maintaining a principled approach to advancing cases to trial. To increase the company's focus on the management of disputes, Scott moved from the law team into a business leadership role as Vice President of Global Strategy. Leading the strategy team with a focus on dispute resolution, Scott ended decades of class action and mass tort litigation involving Monsanto's legacy manufacturing sites in West Virginia, Illinois, and Alabama, and resolved product liability class actions and business disputes. In recognition of developing these transformative programs, the International Institute for Conflict Prevention and Resolution, CPR, honored Scott in 2016 with its inaugural Inspiring Innovation Award. As the agriculture industry began to consolidate, Scott was at the forefront of negotiating and concluding the merger between Monsanto and its new parent, Bayer. For over 20 months, he helped conclude the merger with final approval by all global competition regulators. Following the combination of the two companies, recognizing Scott's unique value, Bayer asked him to serve as General Counsel of Bayer US, a role he occupied from 2018 until he stepped down at the end of 22 to launch Partridge LLC. We're delighted to have you here, Scott, to talk to us about relationship-based dispute resolution and conflict prevention. So please tell us a little bit about the food bank to which you would like people to contribute if they're in a position to do so, and then tell us about relationship-based dispute resolution and conflict prevention. Scott Partridge, the floor is yours.
Thank you, Jeff. It's a pleasure to be with you all, and thank you for inviting me. I'm looking forward to this discussion and want to leave plenty of time at the end for dialogue. So Second Harvest Food Bank in New Orleans. I lived in New Orleans for 45 years, was there through numerous hurricanes, starting with Hurricane Betsy and ending with Hurricane Katrina. New Orleans is a unique American, a fairly poor and struggling population that I saw struggle even more after Hurricane Katrina. So my chosen food bank is Second Harvest Food Bank in New Orleans, and I would welcome and applaud any contributions that you all would be willing to make to Second Harvest in New Orleans. So with that, let me move, and I'm going to tell you a story, and it's a bit of a lengthy story, but I'm going to try to make it somewhat compact. My journey was very predictable when I embarked on the mission. Looking back, I would love to tell you that my journey was linear, and it was not. I started out after graduating from Tulane Law School, working at a large law firm for 15 years, doing litigation. I started out in the maritime field. New Orleans, a vibrant, large port, and there was plenty of maritime litigation. It was exciting. It was international. Maritime litigation, I ended up moving into doing products liability work and ended up with relationships with a number of major manufacturers in the United States who were producing products that resulted in claims and litigation. One of those clients was Monsanto. I was involved in early years with Monsanto before biotechnology in basically garden variety product liability cases. Monsanto didn't have a large volume of litigation, but they had bits of lawsuits all over the United States. I ended up becoming Monsanto's national counsel and held that role for 15 years, handling Monsanto's litigation throughout the U.S. Handled litigation in every state in the United States other than Alaska. Not a lot of corn and soybeans were grown in Alaska. I found that as I worked with Monsanto and ended individual disputes, one of the ways I brought value to the company was by counseling them on how to avoid similar disputes in the future. What I didn't realize I was doing was I was venturing into the area of conflict prevention. The firm I started, we enjoyed some success, growing rapidly, and then we ran into a weather event in the end of August 2005 with Hurricane Katrina. My law office had the top 5 floors of a building downtown right across from the Superdome. Some of you probably recall what the Superdome looked like after Katrina, with holes ripped open in the roof. All 5 of my floors were blown out, windows completely blown out, desks were thrown into the street. We didn't have another satellite office, we only had one office. And we lost our house. We had 7 feet of water for 16 days. We had 5 family members lose houses. My wife and I and our boys lived in 9 different places over the next 12 months trying to get back to New Orleans and rebuild. One of the things I did with Katrina, when Katrina hit, is I asked my partners and associates, call up your best client and see if you can co-locate with them. Ask them to help you, give you a conference room, and the response by our clients was just astounding. One of those clients was Monsanto, and the entire ag litigation group went up to Monsanto, and not only were offices provided, but Monsanto found housing for them, and it was just a remarkable gesture and partnership. Surprisingly, we also had one of the best financial years in the history of the firm the year after Katrina, with all of the help that clients were giving us. So about a year after Katrina, I was making a tour visiting clients to thank them, and I visited Monsanto. And in the course of that visit, I was asked if I would be interested in joining the company as Chief Deputy General Counsel. The then Chief Deputy was becoming the new GC. It hadn't been announced yet. And I went home and spoke with my wife, and overnight, we made the decision that we were going to move to St. Louis. So that was in 2006. And I stayed in the law department for 4 years. And then the CEO of the company, Hugh Grant, asked me to lead a section of corporate strategy. Monsanto has frequently been challenged with reputational issues, the development of ag biotech. While it was transformational in the industry, it wasn't always widely accepted. And Monsanto had a bunch of old legacy litigation involving closed manufacturing sites from when it used to be a chemical company. And my focus was trying to end disputes, and in particular, end the disputes, not only legacy disputes, but also end litigation across the industry. When the race was on to develop biotechnology in agriculture, there were 6 major multinational companies that were in that race: Dow, DuPont, and Monsanto, the three American companies, BASF, Bayer, and Syngenta, 2 German and 1 Swiss company. Well, Monsanto was the first to bring a commercial product to the marketplace and put it in the hands of farmers. And it was there were 2 products really. One was in cotton and one was in soybeans. And the decision we made when that technology was brought forward, recognizing the transformational nature of it, was to broadly license it to all of our competitors. The largest competitor we had was DuPont, DuPont's ag division, Pioneer, out of Iowa. And DuPont didn't really like having to license from this young upstart group out of St. Louis, but nonetheless, it was necessary for them to maintain a competitive position in the seed business. We had constant litigation across the industry, and there's a system that you all have probably seen before when an industry goes through a transformation. The first mover, the innovator, will secure a new product or new development or new process and will patent that product. That's what Monsanto did. The patents end up being attacked by the competitors who didn't win the race. So we had that litigation. We were successful in defeating that litigation, but also had a business model where we were broadly licensing. So government regulators, we didn't have at that time litigation with government regulators. Once the patent estate, so we'd call it a fortress, once the patent estate is secured, you see antitrust attacks. You dominate the industry, you control all the patents, and hence you must be an antitrust monopolist. So we had that litigation as well, and were successful in that litigation. As the technology moved to its second generation, the patent was expiring and new technology was being brought to bear. At Monsanto, we discovered that DuPont had, and I'll use the grade school term, borrowed our second generation technology without permission. We confronted them and said, "You need to stop this." And they said, "No, we're not going to stop it." And we said, "Okay, then you need to take a license." And they said, "No, we're not going to take a license. And if you sue us, we're going to complain to the Department of Justice and to state attorneys general." And this is when President Obama was there, Joe Biden being vice president. DuPont, I'll remind you all, is a Delaware-based corporation with strong political ties in that state. Joe Biden happened to have been a senator from the great state of Delaware. So I attempted to convince them to take a license, and they wouldn't. So we filed suit against them in federal court in St. Louis. Within 45 days, we were met with an antitrust counterclaim and notice of investigation, a civil investigative demand from the Department of Justice, and shortly thereafter, a subpoena of a civil investigative demand led by the state of Iowa, which was DuPont's agricultural unit's home state. Litigation proceeded, and we had over a dozen other lawsuits with DuPont at that time. We had lawsuits with Syngenta and others in the industry. It was a very busy time in courthouses for Monsanto. I attempted to settle the dispute and offered a license to DuPont, but we weren't able to reach an agreement. The case went to trial in St. Louis, and it resulted in a $1 billion, that's with a B, $1 billion jury verdict against DuPont, and a finding of infringement. The antitrust counterclaim was defeated, dismissed. I waited a few months, and I called up the individual at DuPont Pioneer who I had negotiated with, their president, and failed to settle the case before trial. We called Paul. I called Paul and said, I've got $1 billion judgment. I know you're going to appeal it. I'm prepared to license you the technology that you clearly want on the same terms that I offered you before trial. The only thing that will change is the price. And the price has gone up somewhat because of this verdict. He was surprised that I was willing to offer the technology, since we certainly weren't obligated to, and it would have had a significant competitive impact on them not having the second generation technology in soybeans. So we got together. We had a host of lawyers and business people. I had breeding experts, scientists with knowledge of the technology, and we met for 68 days straight and negotiated a license through the patent term of the technology, which took it through 2027. It had a net present value of, I think it was 1.7 billion, and a cash value through the license of 5.1 billion. It was then the largest financial transaction in the history of Monsanto. As we got to a point where it was clear that we were going to have a license in place and the $1 billion verdict was going to be resolved and vacated, I asked Paul at the hotel where we were meeting, I said, can I buy you a drink? And after the day was over, we went to the bar, and we'd spent a lot of time together, 68 days straight. And I said, Paul, I'm pleased to see we're going to resolve this. We have over a dozen other lawsuits that I'd like to talk to you about. But also importantly, I never want us to get to this place again. And he said, what do you mean? I said, we've got to find a better way of competing. I said, when I think about Coke and Pepsi, they haven't been in litigation against each other the way we have. They compete on the store shelves. We should be competing at the farm gate, competing for the business of our grower customers. And he said, well, how do we do that? And I said, well, first, let's put some teams together and let's try to end these other dozen plus lawsuits and arbitrations. So we put together groups, again, of lawyers and businessmen and women. And we had used a mediator for some of the disputes. We did it ourselves for other disputes. And we resolved all of that other litigation. We then started meeting on a quarterly basis. And it's first started, we both brought antitrust lawyers. And we had, of course, other lawyers, commercial lawyers, and brought businessmen and women to these meetings. And the purpose was to have a system in place that when conflicts or disputes or disruption would occur in the relationship in the field or at state capitals, those disputes would get elevated to this team. We called it the relationship team. And it would be led by Paul and me. We also put in place contracts broadly across both organizations that had the standard dispute resolution clause. It called for negotiation by business owners, then executive negotiation, which would be Paul and me, and then mediation, and then arbitration in all areas other than intellectual property disputes. And I'll explain later, if you wish, an interesting way that we created a process for intellectual property patent disputes. What we found was as we worked together and we heard of disruption or disputes in the field, they would be brought to our attention. And what we realized was the vast majority of these disputes, or brewing disputes, were a function either of misunderstanding, lack of communication, or just vigorous competition in the field. And we ended these disputes one by one. And there was great motivation for the business owners to end these disputes, because if they didn't end the disputes were brought to Paul and me. And we would end them. And it was definitely a better program for the business owners to terminate those disputes. the system, while quarterly we started out meeting in neutral locations, everybody had suits on, and we sat across the table from each other. As we ended these disputes and existing litigations, we started having fewer lawyers attend these meetings. We always had antitrust lawyers there. And by the way, I informed the Department of Justice what we were doing. And I told them we would provide you with copies of the minutes of these meetings so you could see that the two largest competitors weren't doing things that we shouldn't be doing from a competitive standpoint. Department of Justice was very appreciative of that. And by the way, the investigations that DOJ and the State Attorney General Task Force opened of Monsanto in response to our lawsuit against DuPont, they all disappeared. They ended with no consent decree, no change in practice. They simply were dismissed after the expenditure by Monsanto of literally tens of millions of dollars responding to their investigative demands. What we found was these meetings, as fewer lawyers attended and more businessmen and scientists attended, I hosted a meeting at our headquarters, and it was over lunch. And I purposely put together a series of round tables, and we sat with each other. I was then invited with my team to go to a meeting at DuPont Pioneers headquarters. We weren't wearing jackets and ties anymore. The attire was casual. We actually met the evening before over dinner and had cocktails and wine with dinner, and we sat next to each other. And as one of the DuPont people said to me, Scott, it's really interesting to see that you all put your pants on one leg at a time, just like we do. And what was fascinating was their sense of values and priorities were the same as ours, putting new products in the hands of growers and competing at the farm gate. Now, let me explain to you why this process worked and where we took it next. I went to Syngenta. We had 14 lawsuits and arbitrations with Syngenta, the Swiss company. I told them what we had done with DuPont, and I said I wanted to construct the same model with you. Now, the Swiss are a bit more structured, a bit more regimented than we were with DuPont, but we formed a governance team that the Syngenta called it, and we had the same sort of process. And we ended all of our litigation and disputes with Syngenta, and we put in place this quarterly meeting process. We did the new contracts, had the standard negotiation, executive negotiation, mediation, arbitration, stepped claims resolution process. And this ended up being a model that we used across the industry. I also watched litigation between other competitors in the industry disappear. And I certainly don't want to take credit for what ended up emerging after 18 to 24 months. I did a search and couldn't identify any litigation across the entire industry: Dow, DuPont, BASF, Bayer, and Monsanto and Syngenta. I would like to think that there was a realization by other companies that we had that time, effort, and resources were better spent elsewhere. And that point was driven home to me when I was in strategy. I traveled a lot. I traveled around the world to places where agriculture was struggling, to places where food was not as abundant as it is here in the United States. I applaud the effort, Jeff, that you and your team are doing, and what you're doing with food banks here in the United States. There are people who struggle in the U.S. to find food. I'll tell you that those of us on this call, you're going to have a choice of what you want to eat for lunch and dinner tonight. You're going to have an abundance of food and selection in restaurants and grocery stores of your choosing. In some respects, those of us who are fortunate enough to afford food here in the U.S., we've won the lottery. We've won the food lottery here. I traveled to places in Asia, in India, and South America, in Africa as well, where people struggle to find food. In Africa, the only sub-Saharan nation that's able to produce enough food to feed its own population is South Africa. And in rural parts of South Africa, much of the food is produced on a family by family basis, usually by a woman who is poking a hole in the ground with a stick to plant one kernel of corn at a time. And that corn has germplasm that's as robust as what our forefathers planted around the time of the Civil War. They're not in need of biotechnology. They're in need of basic tools and infrastructure. And that woman is planting those kernels of corn simply to feed her family the same food day after day. And as I traveled the globe, I saw things that were burned into my memory. And I saw children who were hungry. I saw families who were begging for food. And when you think of the statistics that we face as a nation, and the ability of this country to provide food for people around the globe, tonight, 1/4 of the children in the world will go to bed hungry. And this year, about 3 million children will die of malnutrition. That's about the population of the greater metropolitan St. Louis area. And this is happening every single year. And when I think about the money that we were spending, that we saved in resolving disputes with our competitors and resolving legacy manufacturing disputes, we put tens of millions of dollars back into the budget to be used on the research and development of new tools to put in the hands of growers around the world to help solve this problem. I didn't need any more motivation than that to do what I did, to take the risk. As I told my team, we're going to take the risk of being right here, and we're not going to go to the safe place of not being wrong. And we took the risk of extending an olive branch to our competitors to tell them that we wanted to change the way we did business with each other, and it worked. And it's one lesson that I've tried to bring to the teams I've led, is that take those risks, change the dialogue. The only thing that can happen to you if you fail is you move on to the next opportunity to take a new risk. And I'm really pleased with what we were able to accomplish. To this day, there's very little litigation across the industry. It has matured to a point where I do believe this industry is one that, even through consolidation, even when a state-owned enterprise of the People's Republic of China bought Syngenta, we attempted at Monsanto to be the consolidator rather than the consolidatee, but we were acquired by Bayer. And after 20 months of negotiation, the two companies merged, with Bayer being the dominant party. I was fortunate enough to be asked to serve as general counsel once that merger was completed. Frankly, I was quite surprised to be offered that position, since I sat across from Bayer's leadership for over 1.5 years and helped convince them to pay $63 billion to acquire Monsanto. But it was fun to take the job as my last formal job. I was interested in helping to put together two just awesome legal departments, but I was chagrined that we ended up with 3 adverse verdicts involving Roundup. all around the San Francisco Bay Area. So suddenly my job changed, and I spent a lot of time on the Roundup mass tort multi-district litigation. The company now has had 7 trial victories in a row, and it appears that that litigation is going to die of its own weight, and the MDL mass tort aspect of it be ended. But I spent most of my 4 years dealing with that issue at Bear. I'll also talk a little bit about resolving other litigation. The legacy litigation we had, 3 old manufacturing sites in Illinois, Alabama, and in West Virginia. Some of them involved 20 years of litigation. I used mediators in each of those. But what I did was I was leading the business strategy section at this time. And I insisted, and I told our inside counsel that we're going to ask the mediator to hold a session, and you're certainly going to be there as inside litigation counsel. Our outside litigation counsel will be there, but I'm going to attend as a business executive. And I want to talk to the plaintiff's lawyers on the other side. And I want to build a relationship with them. I want them. I identified myself as the Secretary of State, and I identified the in-house lawyer as the Secretary of War, and made clear that I was here with one purpose and only one purpose, and that was to end this litigation. And we ended up resolving all of those legacy lawsuits, and that also freed up tremendous resources that were no longer being spent simply to defend litigation that should have been brought to an end, frankly, much earlier. Jeff, I want to leave plenty of time for discussion, and I can go deeper in talking about relationship-based dispute resolution. I also would love to talk a little bit about things I like and don't like about mediation process, and some tips for mediators that I've seen work well. But Jeff, would it be okay to open the floor at this point to questions?
Yeah, why don't we start, Scott? First of all, thank you. This is a rare insight to dispute resolution and conflict prevention at the very highest and most sophisticated levels. If you'd like to talk about what you like and don't like on mediators, pluses and minuses of the mediation process, perhaps we ought to give you a few minutes to cover that before we dig into questions and answers on other areas.
I would be glad to. And I see some familiar faces and names here of folks I've worked with before and been in mediations with. A couple of things. It's more about mediation process, personalities of mediators. I really appreciate when a mediator understands that this is my dispute. This is this is my company. This is my problem, and I favor a mediation style where the mediators enable the parties to have as much dialogue as possible at the right time. There's always a certain pace to a mediation, usually starting with all of the participants in one room together and then breaking up and into separate rooms. And you start with the Henry Kissinger style shuttle diplomacy. That's important. It's an important step in meeting. One thing I generally don't favor here, it's probably on my end, I don't favor opening statements unless they are expressions of intent and good faith and goodwill. I also, when there are opening statements, I also appreciate those being provided by the business leaders and not the lawyers. It's important from my perspective that the business leaders take the front seat in mediations as quickly as possible. I've been to mediations where I have had to instruct our outside counsel that they no longer have a speaking role unless I call on them. It's the mediation is not the place to, from my perspective, to get into lengthy debates about relative merits. Most mediations I've attended, almost all of them, are with sophisticated parties who have very skilled and capable counsel, and you're not going to change someone's mind by making a legal argument at the mediation. So I mentioned getting the principals together as quickly as possible. I've resolved more disputes in that fashion than I have via the Kissinger shuttle diplomacy approach. So it's and maybe that's more a sense of style, but I find that if you as a mediator can help facilitate the personal connection between the two principals, if you can find a way to make that work, whether it's putting them together one-on-one at the right time, whether it's finding common ground on a personal level, I really think that the personal aspect of negotiation is critical to the resolution of disputes. It served me very, very well through many decades. And again, it may be just a matter of style, but I think there's a role for that personal connection that's facilitated by a mediator in every negotiation.
Scott, can you give an example? Don't name names inappropriately, of course, but can you give an example of something that a mediator did to facilitate a personal relationship that was really inspired?
Yeah. Just about 6 months ago. Well, I'll tell you what it was. It's very personal, but it was a way to break the ice to get the two of us talking together. My lead opponent, a very capable mass tort lawyer here in the U.S., he recently became a grandfather, and I have 11-month-old twin granddaughters, our first grandchildren. And the mediator learned that during downtime, talking to both of us, and he actually got us together in the hall, and we started talking to each other about our grandkids, and that led to sitting down together at the lunch break, and the conversation went from personal to really a bit of a dropping of hands, and it started the direct dialogue. Instead of the shuttle diplomacy, we started talking to each other directly rather than through the mediator. So just an unanticipated personal touch. I'm always open. I'm always open to any dialogue with my opponent. I find it often disarming to my opponent when the mediator would tell him or her, Scott wants to talk to you one-on-one. And often there's a defensiveness, there's a concern that, there's some trickery afoot, but it's just such a human aspect of dispute resolution to want to have, from my perspective at least, to want to have a direct dialogue, especially when I make clear that my only job, I was not the litigator, I was not the trial lawyer, I wasn't the person who was going to meet them in the courtroom. My goal, and my only goal, is to settle the dispute. If I leave today without settling your dispute, I have failed. And it's interesting, especially when you're dealing with an opponent who is both the negotiator and the litigator. That takes breaking down that instinctive reaction that litigators have to pushing back and fighting rather than building and creating. And what's really important to me is to connect with your opponent in a fashion where you're both understanding that your job is to build and create. and it's hard. Sometimes it's hard to do. It's a lot easier if you end up with an opponent who hires a separate settlement counsel or who actually brings a business person to the meeting if you're dealing in company versus company disputes. I am a firm believer that as mediators, you all should, when you're in the position of, for instance, a company to company dispute, that you should strenuously insist that business leaders attend. That make it a priority. You want business representatives who own the dispute and hence own the resolution.
Scott, so many mediators, when I talk to other mediators are always pushing for this sort of thing, having the clients involved, facilitating the personal touch, the direct communication, as you've been discussing. And I think mediators all across the country will tell you we get a lot of pushback from lawyers when we suggest that. Where do you think that comes from, and what do you think we can do about it?
Yeah, I think it comes in part from the desire for the lawyers to be in control, and second, and I mean this with all appropriate respect to the mediators who are on this call from large litigation firms. The business model the business model for most litigation firms does not endorse swift and efficient resolution. Okay, I don't mean to be snarky about it, but I was at a law firm for a long time. Sometimes there are instinctive motivations that litigators have that are not the same as the motivations that negotiators have. And this is one of the reasons, Jeff, that I think it's absolutely critical to get businessmen and women, decision makers, to whom the lawyers report or who own the dispute in the mediation. I think, I'm not a mediator. If I were, I would try to create. If I was in demand, one of the things I would do to exercise control of the amount of work that was coming to me, I would not accept mediations unless business representatives were attending. I would make it a policy, and I would explain why. That you're going to get a much better result. You're going to get it faster and less expensive, and your chance of resolving the dispute much higher if you bring business owners with you. And I think if there was a statistical study, it would bear that out.
So, Scott, in the context of individual mediations, well, first backing up a bit, is it really up to the business executives and the in-house lawyers to be assertive with their counsel and with mediators to say, you better design a process where I'm involved, and here's the role that I would like to play and the role that I would like to discuss you playing?
Absolutely, Jeff, and that's what we did at Monsanto. When I was asked to lead this business strategy team, I was responsible for dispute resolution across the company, and the lawyers operated at my direction in that regard. And I had direct contact with our CEO, chairman of the board, and on significant disputes, he was my base of authority. And that's exactly what we did. And I made clear that in any significant dispute, we would have my settlement team involved for the purpose of seeing if we could resolve that dispute by way of settlement. And we resolved a lot in that fashion, Jeff, simply by taking control. One thing that you'll find with major companies, when a lawsuit comes into the company, what the law department generally doesn't do, and I'm not talking about just Monsanto, what the law department generally doesn't do is say, oh, wow, let me see if we could settle this quickly. No, so that reaction by the law department to a new lawsuit is, we're going to fight this and we're going to win this. We're going to beat our opponent. And consequently, one of the things I did at Bayer was we had teams working in parallel. We had litigation teams in the law department, and we had settlement teams. And there were lawyers who were responsible for the settlement process run in parallel to the litigation process. They weren't in competition. There were parallel processes that worked collaboratively together, and it was very effective. And my vision was that lawyers from case to case would change from being a settlement lawyer to being a litigation lawyer. So it was an opportunity to grow and develop and understand risks and benefits of litigation versus resolution and vice versa. And it worked very, very well to have people who were dedicated purely to the resolution process.
Do you think that comes just from the culture of lawyering and the culture of legal education, that this is a lawsuit looks like a nail that you have to hit with that particular hammer?
I think, Jeff, it's in part that there's also a romance to being a litigator. There's not a lot of people think it's sexy to be a negotiator and to resolve disputes. The gladiator, the man in the arena, or the woman in the arena, as Teddy Roosevelt would refer to, there's a true romance to that. That frankly, it took me about 2.5 decades to realize that I could add more value. I could add more value if I dedicated my focus to dispute resolution and to ending problems and to putting in place processes to avoid conflicts before they appear. But I think some of it comes out of law school. Also, the litigation machine in America is a huge money-making machine. It is a tremendous. I mean, look at both from the plaintiff side and the defense side. Look at the size of litigation departments of most major law firms in defense firms in the United States, and look at the level of success of some of the most prominent plaintiffs lawyers, whether they be the Mark Laniers and the Joe Rices, the Papantonios of the world. The amount of money they have generated from litigation is just absolutely enormous. They haven't generated that money from settlements. Maybe it's settlements after litigation, but their function has been to create as much risk and as much leverage as possible through litigation.
Scott, now let's focus a little bit on individual mediations. Mediators generally like to get people together for some kind of joint session or other, and we can talk about what that means in a minute. But again, we get tremendous pushback from a lot of mediators. Think their job is simply to put Group A in the West Conference room and Group B in the East Conference room and shuttle numbers between them. A lot of lawyers have come to expect that that's what mediation, quote unquote, is. And it can be a struggle to get people together for that kind of direct communication. What is your view on how to how to get at least more of those ice-breaking joint sessions at the beginning, where at least the business executives can lay eyes on each other, and then we can figure out how to transition into more substantive communications between the business executives?
Yeah, I guess the first step, and we've already touched on it, Jeff, the first step is you got to get the business executives in the room. You got to get them to attend. And that's why I talked about the concept of a policy, somewhat of a policy to try to force that if you can. The other is to avoid the confrontational initial session of saber rattling. And what I really like, and I do this in every mediation I attend, I did it just 2 weeks ago in one that Lane Phillips was handling. We had 35 people in the room, and Lane didn't want opening statements. We weren't going to give an opening statement that set out territory or that rattled sabers. I told Lane I want to have 3 minutes to explain why I'm here and my commitment to do everything I can to get this resolved. And it actually prompted a couple of people on the other side to make similar statements. And what it did was it enabled me to make eye contact in a large conference room with folks I hadn't met before. We went around the table and everybody introduced themselves, and of course, you forgot everybody's name immediately. And but it identified for me people who either volunteered to lead or were natural leaders, and they basically said the same thing that I said. And what it was the first creation of common ground. That's what that did. And very skilled mediators do is seek those building blocks of common ground. And common ground is not built by saying Scott offers 100 and Johnny wants 500. That's not common ground. And before dollars are ever exchanged, some of the best mediators I've worked with have tried to find common ground. And often common ground starts with, in complex negotiations, it starts with structure. It starts with a foundation. One of the worst things that you can do in a complex negotiation, I find in my experience, is start out with money, start out with dollars, start out with value. It will frequently, often crash a negotiation or mediation if you start with what I submit should be one of the last points that's negotiated. Is, if you decide that you're going to buy a car, you don't go to the car dealership and say, pay $10,000 for a car. No, you're going to go in there and you're going to say, I know what car I want to buy. You're going to have a structure in mind before you get to the negotiation of dollars. And I think some of the most skilled mediators I've worked with are ones who look for common ground on a personal level and start with structure.
What are some other examples of structure in the kind of business and commercial mediations in which you're engaged, Scott?
Well, let's take one example I use: patent infringement. Are the parties is the patent holder willing to license, and does the violator want a license, or is it simply the patent holder says you need to stop and I'm not going to license you, and I want to monetize this? In, for instance, a complex mass tort negotiation, it's a mistake to start the negotiation on a per case average. It's I prefer starting with I need to educate my opponent about the structure that's important to me before we get to price.
So, Scott, you said that you wanted joint sessions that were basically expressions of goodwill and intent, and now you're talking about what seems to be some kind of direct communication or joint session that's going far beyond that. So can you elaborate on that a little bit?
Sure. It's important to me to first build the ability to communicate, to have effective personal communications. It's just, I find that negotiations will be slowed or often fail if that initial sense of, and I'll call it trust, that you build, that personal touch, that personal ability to communicate with your opponent. It may take as little as a couple of hours of communication. It could take several sessions. The mediation I mentioned with Lane Phillips a couple weeks ago, we went for 2 days, and we haven't talked dollars yet. We're building a process of being able to communicate and creating a structure. And I suspect we will go on for probably several more 2-day sessions to be able to accomplish what we need to accomplish. And Jeff, I know we're running out of time. I really appreciate having this opportunity to be with you all, and I wanted Jeff to make sure that I was able to communicate to your audience the importance of taking risk in these areas. of taking the risk to do something a bit different, taking the risk to do things that maybe are outside of the traditional in terms of what's been done. I've enjoyed the time with you all. I really have, Jeff. It's been, thank you for inviting me to do this.
Scott, you are so welcome. This was a very enlightening and informative conversation. Thank you so much. I think we covered most of the questions that came up in the chat, and I was happy to articulate those for people. This was just great, and I'm confident that people will be online very shortly contributing to the Second Harvest Food Bank of New Orleans. We'll put the link to that back up in the chat so people can get to it easily. This has been a wonderful presentation, Scott. We thank you and appreciate it very much. The hour is complete and we are complete.